then there are certain apparent reasons on which naturally you will reject or you will not accept the nomination. Person is not qualified or a person is disqualified. As I told you earlier, the crucial date for determining whether a person is qualified or is not disqualified is the date of the scrutiny of nominations, not the earlier date. There may be a situation when a person may be not qualified on the day he has filed the nomination, but on the date of scrutiny he may be qualified. I am just giving a small example. Supposing a person is say 24 years and say 363 days when he files the nomination, but on the date of scrutiny he has completed 365 days. So on that day he is 25 years. So you have to see what is the position on the date of scrutiny of nominations. Then next ground will be where nomination paper is not signed. Candidate has not signed, though the proposer has signed, but the candidate has not signed. Then you can't accept a paper which is not signed by the candidate. Similarly, you cannot accept a nomination paper which is not signed by the required number of proposers. Then our security deposit has not been made. Then security deposit has been made, but by say through check or through some other means which is not permissible in law. He has to give you the security in cash. So he cannot just annex a check of say 10,000 rupees with you. So you will not accept that. Then he has not given you the certified extract from the electoral roll if he is contesting election from another constituency. For that, of course, the law says that when you take up the scrutiny up to that time, he can produce. Then he has not given you the affidavits. Then this is a ground, because Supreme Court has said this amounts to disobedience of the Election Commission's Supreme Court's own order. So, but as I said, if the affidavits are given, but the information is not complete, or the application or information given is defective, or he has suppressed some information, that is not a ground for rejection. You be very sure on that aspect. And sometimes we have seen, particularly in these affidavits, some people just give the affidavit leaving so many columns blank, and then they leave it to the interpretation as to whether this information is nil or some suppression. So our instructions very recently we have given that when the affidavits are filed, you put somebody, some responsible officer, he should go through that affidavit. If any column is left blank, you ask that man, either you put dash or not applicable or something. Don't leave this blank straight away. So you must ensure that the affidavit is properly filled, giving the information, either nil information or the information which is available, not leaving any column blank. And then somewhere the candidate has not given the complete address, and the people are not sure as to who is this man, where he is living. In one case somebody said this particular market, but where in that particular market, where shop, which shop number. So the Supreme Court said no, this is not the address. A person cannot be just hunting where you are in that market. So they have to give the complete address, or complete residential address, or wherever the address he has shown in the nomination paper, that should be a complete address. And then naturally, if it has not been filed within those 11 AM to 3 PM or on the date which is already over, so you can't accept, so that will be another ground. But at the same time, the section 36 also says that don't reject a nomination paper simply because some information which was to be given, he is not properly given. So it's not a defect of substantial character. And the rules clearly say that if somebody has one of the examples given in the rules of a defect of non-substantial character is that a person has not filled his declaration with regard to the symbols. Supposing a person has to say these are the three symbols of my choice and he has not filled, or supposing he has filled those symbols but shown some symbols which are not even available in the list of the specified symbols. So that is not a ground for. So you have to just see, and then somewhere they have said, in one or two cases they have said that a person has given the serial number and the part number etc. of his proposals, and those proposals and the serial numbers, when they were checked, they were not correct. The part number was not right or the serial number was not right. Then in that case, Supreme Court has said that if the candidate is available or his agent is available and he can give you the proper information that by mistake I showed this part number or the serial number maybe from the earlier roll, but now this is the exact number, and if you by reference to that electoral roll you can find out that yes this is the, then you can ignore that. That they have said is will not be treated as a defect of substantial character. But at the same time they have also said it. A candidate is not available, and on the scrutiny and the verification of the nomination you see that he has said my proposer is at serial number so and so in part number so, but that is not there. Somebody else's name is there and the candidate is also not there. Then there is no responsibility on the part of the RO to just go through and then find out whether the man is registered somewhere. If the candidate is there, he can assist you and in location of the right man, it's okay. That is not a defect of substantial character. But if he is not there, it's not your job, and then it will become a defect of substantial character. So this is what you have to just see at the time of scrutiny. And then, as I have already explained, wrong information in the affidavit is not a ground, but the total absence of information is the ground for rejection.